Can Ripple beat the SEC? When will Ripple present new arguments in its defense? How much will XRP cost after the trial ends? We will answer these questions in today's video. In the meantime, subscribe to the channel and we're getting started. Despite both parties in the Ripple and Securities Exchange Commission (SEC) case making final submissions and awaiting summary judgment, the main focus still lingers around the regulator's power in providing oversight in crypto alongside unsealing vital documents. Under the latest update, pro-XRP lawyer John Deaton has questioned a statement by SEC Chair Gary Gensler alleging that any crypto besides Bitcoin, DC, is classified as a security. It is worth noting that the SEC is using Ripple for selling XRP as security. In a tweet on February 27, Deaton stated that there is no consensus regarding securities classification. He made the remarks in reaction to a comment by MicroStrategy Executive Chairman Michael Saylor, who noted that Gensler's remarks are testimony that consensus is building on the classification of security. Previously, Deaton shared the possible arrangements for both parties to settle even as they await the summary judgment. According to Deaton, Ripple would pay $150 million in a settlement if the regulator agrees that ongoing and future sales of XRP are not classified as security. However, he cautioned that the likelihood of the SEC agreeing to the approach was minimal, considering the agency's increased crackdown on the digital asset space. Deaton pointed out that the presiding judge could clarify XRP's secondary sales in this case. It is worth noting that Ripple General Counsel Stuart Alderoty had earlier insinuated that the SEC has minimal chances of winning the case at the Supreme Court based on historical outcomes. The SEC has lost 4 of its last 5 cases in the Supreme Court, thanks to the few that had the courage and resources to fight back against the SEC's bullying and clinging to stretch legal positions that were not faithful to the law, he said. As previously reported, the case received new rejuvenation after a journalist, Rosalind Layton, filed a motion to gain access to the Hinman speech documents. The speech was issued by the former director of the SEC's Division of Corporation Finance in June 2018 and could offer a clear representation of how the SEC classifies securities. Hinman noted that Ethereum, ETH, and Bitcoin are not securities and the same approach could be applied to XRP. Elsewhere, defense lawyer James Fallon also revealed a new development in another long-running legal battle where Ripple has been facing a class action since 2018. In the matter filed in California, XRP investors sued the company and its CEO, Brad Garlinghouse, for selling XRP as an unregistered security and are seeking damages for the losses they suffered. They are requesting that the court declare XRP a security. As reported by Feinbold, Deaton had filed a motion to join the matter as an amicus brief. In the latest update, the plaintiffs filed another motion opposing Deaton's prayer to be included in the matter. Stuart Alderoty, Ripple's chief legal officer, has said that Gary Gensler needs to stop making decisions about how cryptocurrencies should be categorized in the future. Today, the lawyer said that it was likely that Gensler would make biased decisions in the future. He did this by bringing up a recent interview in which the head of the U.S. Securities and Exchange Commission said that every crypto asset except Bitcoin was a security. Chair Gensler has said again that all cryptocurrencies except for Bitcoin are unregistered securities. Since he already knows how the case will turn out, he can't vote on any enforcement case that involves that issue, tweeted Stutter. Gensler said in a wide-ranging interview with New York Magazine on February 23 about the cryptocurrency market that all other cryptocurrencies were securities because there's a group in the middle and the public is expecting profits based on that group, which he said was not the case with Bitcoin. So his words were taken to mean that all crypto assets except for Bitcoin fell under the SEC's jurisdiction, which got a lot of backlash from the crypto community. Jake Chervinsky, a lawyer and policy lead at the Blockchain Association, said in a tweet that Gensler may have already decided that every digital asset other than Bitcoin is a security, and that until the SEC proves its case in court, it doesn't have the right to regulate all cryptocurrencies. The lawyer also said that Gensler's opinion is not the law. Even though the commissioner said he was in charge of the cryptocurrency business, the lawsuit against Ripple, which has been going on for years, is getting closer to a conclusion. But the community is still waiting for the court to decide whether or not XRP is a security. Even though we don't know what will happen with the case as a whole, we can look at what has happened in similar cases to get an idea of what could happen. In March 2021, the SEC sued Elbri, a blockchain-based sharing platform, for selling its LBC tokens without first registering them with the agency. But a Court of Appeals judge just decided that LBC tokens are only securities when they are sold during the primary sale. Many people think that Ripple is likely to get a good ruling if it can prove to the court, like Elbri did, that it never held an ICO. If Ripple wins, XRP could be put back on exchanges like Coinbase and Binance. This would make the coin's price go up by a lot. David Schwartz, the chief technical officer of Ripple, has changed his Twitter profile image to a photo with a message. The context and the term Ripple at the top indicate that it refers to the SEC's action against Ripple. Members in the crypto world are speculating on what Schwartz may imply and if there are any indications on the case's conclusion. When a scrappy financial startup takes on a web of corruption and betrayal to bring instant payments to the masses, they learn that the cost of disrupting the status quo is higher than they could have imagined, forcing them to choose between their vision and their survival, says the message on the profile picture. Several crypto aficionados on Twitter have reposted and commented on screenshots of this message, as they attempt to figure out what the C2 of Ripple and co-creator of XRP Ledger possibly mean. They do, however, agree that this is most likely a legal battle with the U.S. Securities and Exchange Commission, which has been ongoing since late December 2020. Many members of the XRP army started tweeting their support for Schwartz, EO Brad Garlinghouse, and other Ripple executives who are working with the legal team to win the lawsuit and preserve the crypto sector from SIA control. As many crypto fans think, the SEC seems to be attempting to declare digital assets as securities and regulate them using securities law going back to the very analog early 20th century. The Twitter account Ashley Prosperone thought that the objective of Schwartz's tweet is that Ripple may have to sacrifice their goal for the firm in order to exist as a corporation, i.e. just persuade the SEC to recognize XRP as a non-security, as Bitcoin and Ethereum do. John Deaton, the creator of CryptoLaw, U.S. and an outspoken defender of Ripple against the SEC, has revealed what he thinks is the primary condition on which the fintech startup will agree to settle with the SEC. According to his latest Twitter thread, this is if the SEC signs a document stating that XRP is not a security, including current and future sales, as well as secondary market archer sales by any person or company such as cryptocurrency exchanges. He feels that 1010 attorneys advise settlement in this matter. Deaton believes Ripple would refuse to compromise because it would battle for all of cryptocurrency. He believes Ripple will have to settle because it serves as a fiduciary to its owners. Ripple would be in litigation for a decade if they turned down a chance to settle the case and lost.